Hey, this is Danny Weber, a broker here in Austin, Texas, and today we're going to talk about the eviction process in the state of Texas. Okay, let's get started. First thing, a little bit about me. I'm a real estate broker here in Austin, Texas. I've also got a mortgage company and an insurance company and also a property management company. You can find us at myhomesimple.com on the real estate side, and the property management side is PM512. That's the Texas Property Manager, or Home Simple of Texas. Quick disclaimer, I am not an attorney. You must seek your own legal advice if you've got any questions. I do not favor tenants or landlords in any way. Evictions are definitely a lose-lose situation for both parties. This video is for information purposes only. You definitely want to check with your local county and the state for any updated laws and filing requirements. So what's an eviction? Eviction is basically forcible entry and detainer, and we're going to reference or go through some of the Title 4 Chapter 24 Property Code, but this is the basic definition of an eviction. And evictions, as we know it, are basically a way to legally take possession of a rental property. And so you can definitely read this at your own time. Legal resources, you want to reference Chapter 24 of the Texas Property Code, Title 4. I've got a link right there. You want to check with the local authorities, the Justice of the Peace, and the precincts to see if there are any specific filing requirements, any specific forms that they require. For a tenant, you want to seek legal counsel or professional service, and the same thing for a landlord. And I know that there are some free legal resources out there, but you're going to need to search by county just because it's a pretty exhaustive list, and I can't put that in here. Step 1 to executing an eviction. That's going to be the 3-day notice, and for the landlord side, this is the most important part of the eviction process before you get to court, because if you fail to do this correctly, your case will get dismissed immediately in court. And so here are the actual regulations to do this, and this what the statute says. And you want to make sure that you bring evidence that you executed the 3-day notice as per the statute, and you want to take photos, bring receipts if you're going to do certified mail. Just make sure you're prepared to justify to the judge that this was done in accordance with the law. Step 2, you have to file, and so you're going to file at the local JP, the precinct. Some recently, last couple years, have gone to online filings. Whatever it is, you're going to have to file and more than likely update or upload some documents, bring some documents in with the filing if you have to do it in person. But again, you definitely want to check with the precinct before you just show up unprepared. And that's step 2. Step 3 is going to be you're going to get a notice. And so the tenant and the landlord will both get a notice as to when to appear and where to appear for the hearing. And on both sides of this, you do not want to try to avoid the notice. You're typically going to get somebody knocking on your door and handing you a piece of paper with a notice on it. You may get something in the mail. Whatever it is, do not try to avoid it. It does not help the situation. And you're typically going to see this within a couple weeks of the filing. Now, due to current circumstances, I'm filming this in July of 2020. Due to current circumstances with this, with what's going on in the world, it could be longer. So just be prepared for that and be patient. If you don't receive anything within, I'd say, 2 weeks, you're going to want to call the Justice of the Peace, the precinct, to find out what's going on. Step number 4, the hearing. So you're not going to be the only one in court if they're actually having in-person court hearings. You're going to be, one of 20 or 30, because most of the precincts schedule their eviction hearings 1 or 2 days a week. So there's going to be a lot of folks there. And you could be online. I know that I think Travis County, is doing online hearings right now via Zoom or some other software. So whatever it is, the requirements are always going to be the same. Be on time, be dressed appropriately, and make sure that you've got your evidence ready to go. And you want to send those in typically ahead of time, or you may have to upload them If you're going to be in person, you typically want 3 copies, one for the judge, one for the plaintiff or the defendant, and one for you. If you have audio-visual, make sure you let them know ahead of time and find out how to get that played appropriately in court or online. These proceedings go pretty fast. If you've ever been to an eviction hearing and had to sit around an hour or two, they can burn through 10, 15 different cases before yours is up. And so I always tell folks that if you're going to represent yourself in an eviction hearing, or you're just not comfortable with it, go ahead of time before your time, or go the day before if they're going to have eviction hearings, and just sit in there and listen to what happens, because you're going to see a lot of folks come in there that thinking they're going to win, that are going to lose, and the folks that think they're going to lose, some of them win because of technicalities, and then they're just not prepared. And so you can learn a lot by spending a few hours listening to eviction hearings. If you have a payment plan from the tenant side and you've made some payments already, bring in the evidence. Certified check, cashier's check, whatever it may be, payment receipts, bank statements, whatever it is. And keep in mind that when you go to these hearings, you could win, you could lose, or they could postpone or reschedule the hearing for some reason. You can ask for a future date if you have a valid reason. Step 5, if you are on the losing side as a tenant, meaning you go in there, the landlord filed as a plaintiff, you're the defendant, you get in there and you lose, the judge files in favor of the plaintiff, the judgment's against you. The judge is going to give you X number of days to vacate the property. If you fail to vacate the property, they can file what's called the landlord can file what's called a writ of possession, which is basically they come in there and forcibly take possession of the property with the constable or with the sheriff. And if they hire some labor, they can actually put your stuff on the street. It's extremely messy. You want to avoid this at all costs if possible. If you're not going to, if you're okay with giving the property over, fine. Or if you're saying, hey, I want to appeal this, then you can appeal this typically to the county level. It's going to cost you some money for a bond, and unless you have some new evidence that you can introduce between point A and point B, or you feel like you just got shafted for some reason, you are probably going to lose the appeal. But again, seek legal counsel. I don't know the specifics on your case. It could be in your favor to do that. If you are on the winning side as a tenant, follow the orders from the judge, and they'll tell you what happens next. If you're on the losing side as a landlord, you will typically know exactly why your case was lost, and you'll have the ability to refile at a later date. But typically, when I see landlords or petitioners lose cases, it's because they didn't follow the 3-day notice rules set out specifically, or they failed to bring adequate evidence. Meaning you just don't want to show up to court on either side, the tenant or the landlord side, and just say, well, he said, she said, maybe, sort of, should have. You want to avoid verbal communications and have everything in writing, all your communications in writing, and then those types of things you want to have in triplicate so that they can be handed around and everybody's on the same page. If you're on the winning side as a landlord, follow the orders from the judge. You're going to have to wait a certain number of days for the tenant to possibly file an appeal. If they do not file an appeal, you'll be able to file a writ of execution. And then that'll take 2 or 3 days, could be 5 or 10 days to get through the system. And the constable or sheriff will call and schedule a time to meet you at the property. And they do this after they've given notice to the tenant at the property, typically in person. They put the notice on the door, 24-hour notice. But long story short is there's going to be a little bit of a wait between the time that you win the case and the time that you can physically file for the writ of possession. And then there's going to be another wait for the time that you can physically show up at the property to take possession with the constable or the sheriff. In my opinion, it's better to negotiate with the tenant to leave on their own if possible. You really, both sides want to avoid the writ of execution because it gets really messy at that point. And so if the tenant says I can be out in 4 days or 6 days, whatever it may be, and you believe them and they're packing, they've got boxes, you definitely want to go with that plan versus doing the WRIT, if at all possible. And again, that's my opinion. Miscellaneous notes. The Texas Property Code lays out rules for procedures to recover unpaid rent, ways the tenant can appeal, how much rent the tenant owes, how the landlord can make the tenant pay the landlord's legal fees, and what the sheriff constable will do with the tenant's property if a writ of possession is executed. So just keep that in mind. You can reference that, the Title 4, Chapter 24. Things to bring to court. Just some quick notes here. A copy of the deed if you're the landlord. If you're part of an LLC or an S Corp the property's in, you're typically going to need to bring some type of articles of organization, maybe a designated agent letter, something along those lines, to prove that you have ownership or the ability to represent the owners. Copy of the lease. Both sides should bring that. Rent receipts if you've got rent receipts, rent ledgers, bank statements if you want to prove that you've paid the rent, canceled checks, any witnesses that you may have, and that typically doesn't apply if it's just a non-payment of rent eviction procedure. Complaints from other tenants or neighborhoods, possibly pictures or videos if there's damage, and then copies of any correspondences. Again, you have to keep everything in writing. Once you find out you're going to court both as a landlord or a tenant, you typically want to cease all verbal communications and say, just for the purposes of the proceedings, let's keep everything in writing so that there's no misunderstandings. Writ of possession. Let's say as a tenant you lose and you don't file the eviction, the time goes by. Eventually the landlord may file a writ of possession if you haven't worked out terms earlier to hand over the property. And you'll get a notice on your door, typically to vacate within 24 hours. And even though it says 24 hours, sometimes the constable or the sheriff can't get over there, for the next 3 days. And so it may say 24 hours, but realistically they may not show back up at your door for another 2 or 3 days to, physically escort you and the family out or whoever's on the lease. And it's a horrible thing to do. And then, the landlord would have labor at that point to actually put your stuff by the street. And again, I always really push avoiding this. Figure out how to. It's just incredibly embarrassing and incredibly. It's an emotionally horrible thing to put your family through. But it's the landlord's onus. They've got to hire somebody to put the belongings by the street. So. And then as a landlord, you're going to want to change the locks and access to the property. And again, if you get to this point, I've said this a bunch, but I'm going to keep saying it, seek legal counsel to verify all this and to find out what your options are. Thoughts from the tenant side. If you're being evicted for non-payment of rent, it's typically going to be hard to win in court unless there are legal issues with the initial filing or the notice. It's better to negotiate a move-out date ahead of time to avoid forcibly being removed. Get everything in writing. Remember that if you're not paying the rent, the landlord must still pay the note, the mortgage. So they're being hurt financially because of this. And it may not be your fault, right? You could have lost your job. You could have other bills that came up that took precedence, whatever it is. But the landlord is still being affected negatively by this. And again, we're assuming that it's non-payment of rent, not something else. But the landlord is still being negatively affected by this. For most landlords, this is a business. When they're losing money, it hurts them and their family financially and emotionally. So don't assume that this is just one side of the coin and that you're a victim, because there are two victims in this. One is going to be the tenant, one's going to be the landlord. So I always try to coach people into looking at least both sides of the same coin to figure out if there's a way that both can walk away with less of a loss. And as a tenant, you need to have a plan A and a plan B. Plan A is you win, you get to stay longer or permanently, depending on the issues. Plan B is I lose, and if you lose the case and you don't plan to appeal, or you don't have what you consider enough evidence to do the appeal after seeking legal counsel, you definitely need to have somewhere that you can go. You need to plan on having a family member, a friend. I'd look into a storage unit at that point, but whatever it is, do not put your head in the sand. This will not go away, and it's only going to get worse if you ignore it. So please, please, please talk with family and friends about what your plan B would be if you lose. Thoughts from the landlord side? I've stressed this before, but make sure you follow the notification guidelines to the letter. I've seen cases dismissed immediately if this is not done. Make sure you have 3 copies of any evidentiary documents. Do not be confrontational with the tenant at the hearing, obviously not the judge. It's always better to negotiate a handover without going to court. That's my opinion. Seek legal counsel or a professional eviction service, property manager, to help with your evictions if you haven't done one of these before, or if you just don't want to handle it. You typically have to reference a specific provision of your lease, meaning non-payment of rent, meaning unauthorized pet, unauthorized tenants, or unauthorized people on the lease that are staying at the property but not on the lease. Have total rents due calculated in an easy-to-read format for the judge. Do not show up to court with some scribbly scratch on a piece of paper saying this is what they owe for rent if it's past due. You want to have an actual balance sheet or a ledger that you can present the judge. Do not go into the dwelling if the tenant refuses access. Typically in Texas, you're required to give a 24-hour access to go into the tenant. If the tenant refuses to give you access, then they're basically violating the lease. But again, you can't kick in the door and go in there at that point. Seek legal counsel, talk to the constable, the sheriff, to an attorney. Include all tenants on the eviction filings. One of the mistakes you can make is if you got 3 people over 18 in the property and you file eviction on the mom and dad, but not the 22-year-old son living in the property. That could be an issue. So everybody on the lease needs to be on the eviction filing. Get everything in writing. Avoid verbal communications, and consider cash for keys. Again, the opposite side of the coin we just talked about is that the tenants could be going through an extremely emotional hardship or financial hardship, and maybe they need a little bit of help with assistance with moving on, maybe with moving expenses, maybe if they just got maybe if somebody rented a U-Haul truck for them, or gave them $500 towards moving expenses, that would be enough to get them to their next stop, which would relieve the pressure on both parties. But again, just assume that both tenant and landlord are going through hard times. This is a lose-lose situation, and everybody needs to get out of this situation with the minimal amount of pain and torment. So treat everybody with respect throughout this process. Bottom line, just to reemphasize this, I've said this a ton, I'm not an attorney, I'm not giving legal advice, I'm just doing a brief informational overview of the eviction process in Texas. Prepare Plan A and prepare Plan B if you think you're gonna lose or you may lose. You want to have both of those working. Worst thing you can do is avoid these situations. It's not going to go away. It's only going to get worse. Again, if you've got any other questions or need references or referrals, I am at danny.weber@gmail. On the real estate side, real estate broker side, and then on the property management side, we're at danny@pm512, and that's www.pm512.com. Everybody, please stay safe in these trying times, and just again, I want to reemphasize this. These are 2 sides of the same coin. Both sides are losing if you're doing an eviction. Please try to remain respectful of both parties throughout this process. Thank y'all, and y'all have a great day.